Yes, please, Lordship. My Lord, by your Lordship's permission, I would like to make a mention. Part 2, item number 6. This may be taken up as fixed item next Monday, that is 23rd June.
Have you spoken to the
My Lord,
council
yes,
for the opposite
yes,
side?
yesterday.
Yes,
Yesterday,
both of you agreed
yes.
on the submission made by Mr. Lal Remtluanga, learned counsel for the appellant, with the consent of the councils of the respondents. Lists this matter on, what's Monday?
23rd.
23rd, 6, 2025. Yes.
Macam mana?
For motion, item number 1.
Lordship, this matter, I have taken step as directed by this honorable court regarding that enclosures of the appeal, memo of appeal.
Okay. Oh, yes,
I have
you
enclosed-
had approached the appropriate authority.
That your intention, you are trying to pass the order since that petition was misplaced and I was directed to enclose
Okay,
this
okay,
one.
yes.
My lord, but in respect, my lord, I have very humble request
Huh.
because that the intention of MFA is that to call them personally, as we have seen in Annexure 5 also, because
Annexure
I file this thing appeal, if you lordship see.
So
Annexure-
wait, in your appeal,
Yeah.
let's see a prayer portion.
My prayer is page number 41.
41.
Yes.
In the appeal filed to the MFA, is it?
Yes. So, my lord, what I would like to submit here is that it is at page number 112. If you kindly see
No,
112.
41 is your prayer in the writ petition.
Yes.
Then your prayer before the appellate authority is at page?
My lord, this my prayer at 1 dot appeal start from page number 62.
Huh?
And I
And
have
then?
enclosed detail. So my prayer in my appeal is at page number lordship start from
It's at 89?
89.
89. So
Yes.
if it's the same, then I was thinking we can wait. No? So let's see. Is
My
it
lord,
the same?
Yes, it's same. But one thing, my lord, I would like to make request is that after they receive this appeal, they sent a letter.
Okay.
So their intention is that they do not want a lawyer to be present in the appeal. So specifically, letter was sent to me on page number 112. If you see 112,
112.
yes, 112. Yes, this is the letter sent to me.
To so and so, yes.
Yes, so these are the petitioners herein. So here the intention is that they will send in person and to appear in person without me. So because there is a rules in AIFF code and 109, I have this one also, the code also.
109.
109, my lord, may I kindly furnish this code?
Yes.
Yes.
Power of attorney.
109
So,
is-
with your
Because
power
what
of
is not
attorney-
specifically written that right to represent by legal counsel.
Okay.
It is written that.
So you go and appear and then you explain it to them. Maybe
That's
they
why.
can-
But I was not allowed to be present, and they sent me this letter also. After that, also they sent letter, and it starts from 115.
Wait, this disciplinary this thing. Okay, where's this thing?
109. Page
109.
number 50.
109. Representation and legal. Okay, a party may be legally represented. But see, just a party may be legally. Then point 2, if a party is not required to appear personally, they may be represented or
Yes.
legally. So if a party is not required
Yes.
How do you interpret this not
Because
required?
then they may be represented if that means that because I have already executed power of attorney also to represent them, they are required to.
So where have there, is there a written communication that your presence is not accepted?
My lord, no, it's not written, but it will be appear in person. It was written in 112 and 115 also. It is written that.
So, anyway, when were they supposed to appear?
My lord, as per this letter, they are supposed to appear on 15 February.
Oh, long time back.
No, that's on the evening of 14. They just simply called the coach. And this was cancelled. We'll intimate you shortly, another day. So till now, we have not been intimated.
Okay.
So my simple prayer is that to be represented by the councils of their choice, as per 109.
Okay, we'll dispose of
And
accordingly.
also that MPL, the next version is coming on July. So this case is a kind of immediate urgent. If it can be done within 7 days or 10 days, then it will not become infructuous.
Okay, when is the next, this thing? The next what? Next?
No, July.
What is July?
That there will be another this thing MPL Football League.
Okay, Football League.
Yeah,
Okay,
because in
Mizoram.
this league they are suspended.
MPL is
Mizoram
Mizoram
Premier League.
Premier League. Okay. So that you are not, July what? July?
July, actually, the date exactly they have not specified, but
In
first
the
week of
month
July.
of July. So should be, okay. I'll pass the order
Yes.
accordingly.
Your Lordship, if I may be allowed to make a few submissions at the preliminary stage. Your Lordship, this particular petition cannot be entertained by this court since they have also quoted the judgment Ajay Jadeja versus Union of India. So in that regard, Your Lordship, if you look, it is not a similar case because if you look at the precedent set and the ratio decidendi which is given in par number 32 of that judgment, Your Lordship, the Mizoram Mizoram Football Association cannot be
It's not
similarly
what?
situated with the BCCI. Your Lordship, if I may present the copy of the judgment, Ajay Jadeja versus Union of India. The ratio
Yes,
decidendi
yes.
placed is very different, Your Lordship.
So why was that judgment cited? Why was that judgment cited?
My lord, I have cited in my petition.
Why was it cited? To prove what? To show what?
I'll come.
What is the point of citing this judgment?
But I have cited in para 35 of my petition, Your Lordship.
Why have you cited this judgment?
My lord, actually, there
You
can
are the
be.
petitioners.
Yes.
So it is to see whether you can sue but the state of Mizoram is also made a party.
Yes, my lord.
It is
because,
made a party,
My
yes,
lord,
Lord.
this fact is that they extract all the statement from the police station. One of my first prayers is that call for the report from the police station. I have not only, this is not a single
What is the
party.
bag? Anyway, let's see this thing. Page, para.
Par number 35, Your Lordship. Page number 38.
Where was this judgment cited?
Your Lordship, this judgment was basically cited as to determine whether the
They deprive their rights of livelihood. Okay.
and also with regards to Article 12 of the Indian
Okay,
Constitution. Your
whether
Lordship.
the High Court can entertain writ petitions against sport associations.
Yes, Your
Is it?
Lordship.
Like Board of Control, etc., etc.
Yes, Your Lordship.
Now, in this instant writ petition, he has also made the respondents a party, the state government a party.
Yes, Your Lordship, but that is only limited to the fact that they were brought to the police station. And however, as per my verbal instructions, there are no case registered, Your Lordship, because they realized that this is not their purview, and they said that the MFA should take the issue up. That the MFA should take up the issue, Your Lordship. So they have an alternate remedy with the according to the IAFF 2024 code, and also the appellate authority has the jurisdiction.
At this stage, since there's an appellate authority, will dispose of the writ petition by telling them to dispose of the appeal. Okay. Thereafter, if the appeal is disposed of against their favor, and they come to the court filing a fresh writ petition,
Yes, Your Lordship.
then at that stage,
Yes, Your Lordship.
you will look at your ground.
Your Lordship, they have another second appeal also to the arbitration court as per their IF
So they can
2024.
exhaust all their
Yes, Your
remedies
Lordship.
first. Okay, after that, if they come to the court again,
Yes, Your
then we will see whether they can actually approach this court.
Yes,
for
Your
such a
Lordship.
remedy. I think that we'll see. So I'll dispose it of accordingly. I'll pass the order later. And since they have not exhausted all their remedies, we'll say to exhaust their remedies and dispose the petition accordingly. Maybe to appear, dispose it of within 2 weeks. Okay, I'll pass such an order later.
Yes, Your Lordship.
Represented by the council, my lord.
No, we'll just say to take note
All right.
of this. I'm not going to give any specific direction, okay? By taking note of,
109.
I'll leave it to you, keep this with me. Okay.
Item number 2.
Tweak on my hand. Yes.
Lordship, this writ petition is for non-payment of compensation to the petitioner with regards to the land value for acquiring the landed property of the petitioner, Lordship, covered by his periodic pata located at Khozoldin Thar, Lordship. And his land has been acquired for the widening of road in the National Highway 6 at Khozol district, Lordship. And the reason for not payment of land value to the petitioner was that no sufficient amount in the joint account of Kala GM. GM stands for General Manager, Lordship. Lordship,
That's all?
yes,
No sufficient fund. Who's
Yes, no
supposed to make the payment?
NHIDCL, Lordship.
So NHIDCL is supposed to then deposit the money, isn't it?
Deposit money to the joint account, Lordship.
Black and white, as from what you're saying, it looks like that. So we'll see. We'll show notice.
Lordship, yes.
You heard Mr. Johnny L. Tocho, Learned Counsel for the petitioner, who had filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ to the respondents. The case of the petitioner is that the petitioners are the owners of the landed property at which place?
At Khozoldin Thar, Lordship.
Khozoldin Thar. And the respondents have acquired the landed property for the construction of which what road?
Lordship, widening 2 lanes with pavement
Okay, for the widening of 2-lane pavement
of National Highway number 6.
of the National Highway number 6.
6.
However, the respondents have failed to pay the compensation for the acquisition of the land on the ground that there is no sufficient amount in the joint account of Kala GM. Accordingly, the instant writ petition has been paid for the compensation of the acquired land. Issue notice of motion to the respondents. Mrs. Caroline K. Lalungoipui accepts notice on behalf of the state respondents notice be issued to respondent's number.
See, I've already.
4 is the Kala.
Kala, yes, and.
I
For,
will be appearing for respondent 1 to 3. 4 is
okay,
Kala.
learned government advocate for respondent's number 4 and 3, is it?
1 to 3. 1,
Okay,
2,
1
and
to
3.
3. Accepts notice on behalf of the state respondents. Okay. Notice be issued to respondents number 4 to
4 to 6, 4 to.
4 to 6.
No,
is it?
Lordship, no.
Oh, how many respondents?
4 to 10, Lordship.
Okay, 4 to 10 through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. Requisite copies of the writ petition to be duly furnished to the learned government advocate. Yes.
For admission, item number 3.
Your Lordship, we have received the affidavit in opposition filed by respondent number 5, and as my senior, Mr. Villaramenga, is going out of station if the matter be taken up after 2 weeks, or maybe after the
Okay.
entry of vacation.
Is your name here in the cause list?
Yes, my lord.
Okay. Mr. Lalong
Lomo Marante.
Laloma Morante, learned counsel for the petitioner, is present and submits that though the affidavit in opposition has been filed by the respondent number 5, he has prayed for adjournment of the matter. 5 comma, okay, he has prayed for adjournment of the matter since his senior, Mr. B. Lalram Enga, is out of station. Then, then Mr. C. Lalthiang Lima, learned counsel for respondent number 5, is present along with Mrs. Caroline K. Lalumoypui, learned government advocate for the state respondents. In view of the above submissions, list after
After vacation, ma'am.
the ensuing vacation.
Right, ma'am.
Item 4.
May it please your lordship, the appellant submits that the affidavit in opposition has been received from the respondent. The appellant further prays that the matter may be posted for hearing at the appropriate stage.
Wait. Now, what is the IA which was disposed of? It's for condonation?
Yes, your
So
lordship.
now it's the first time it's coming up, isn't it?
Yes, my lord.
So is your name here in the cause list?
Yes, my lord.
What's your name?
Silal Rimpui.
Heard Ms. Silal Rinpui, learned counsel for the appellant. What is this? This is an appeal filed under filed under section 17,
17,
within
yes.
brackets 2, within brackets B of the Mizoram Civil Courts Act, 2005, read with section 9 of the Civil Procedure Code, 1908, against the judgment and order dated 20/06/2024, passed by the learned civil judge, within brackets, senior division -2, close bracket, Aizawl district, in succession case number 655 of 2018. Good stuff. Why are you grieved by the succession case?
My lord, the learned tri-court has passed an order to share the amount remaining in their late mother's account equally. However, the appellant is the one who have supported the late mother till her demise and is an unmarried daughter. So that is the main issue, your lordship.
So evidence was taken?
Yes, my lord.
Evidence was taken before the trial court?
Yes, my lord.
Then maybe in the evidence, it transpired that you were not taking full care of the mother.
No, actually, Your Lordship, the evidence on record has proved that they were indeed divorced, the appellant and her ex-husband.
Okay, so-
However, since there was no divorce certificate, even though they have admitted that they were separated and they were divorced, but since they did not have a divorce certificate, so the learned trial court has deemed that they are not divorced. So they were still married, even though they have admitted on record that they were
The
divorced.
appellant or the respondent?
The appellant. The appellant.
The appellant.
Yes, my
So
lord.
you're the appellant.
Yes, my lord.
So what do you want?
We are not,
If you're saying that you were divorced,
yes, my lord.
your contention is that you were
Contention is
divorced.
that since since the appellant is an unmarried daughter, then she has the right to acquire the amount, the
Okay,
full
so the
amount.
deceased is your mother, is it?
Yes, yes, my lord.
The learned counsel for the appellant submits that the appeal is filed mainly on the ground that the learned trial court had failed to appreciate the evidence in its proper perspective by not considering the fact that it is the appellant who had looked after their deceased mother. What's her name?
The deceased mother, my lord,
Lalroni,
already
late
late.
till her death, and therefore had erred in issuing the succession certificate, also also in favor of the respondents, is it?
Yes, my lord.
Full stop. Appeal is admitted. Issue notice to the respondents. Yes, Mr.
Lordship, I appear on behalf of my senior Rosalind Elmar, and my senior is on legs at courtroom
Okay,
to
but you can accept notice.
Yes.
Mr. What's your good name?
R. Valarwata.
Vandalwata accepts notice on behalf of his. Is your name okay? On behalf of the respondents, requisite copy of the appeal. Okay, so I'm saying Miss Rosalind Elmar, is it? Accepts notice on behalf of the sole respondent, requisite copy of the appeal memo to be duly served to the learned counsel for the respondent. LCR is required or what? TCR?
Yes, my lord.
It will be required?
Yes, my lord.
TCR to be called for, list after 2 weeks.
Obliged, lordship. Obliged.
For orders, item number 5.
May I please, my lord? My lord, I was led by Mr. Pak if the matter can be taken up on 22nd of July, my lord.
What is the state?
My lord, this IA is for additional evidence, however, I did not have the brief with me.
Okay, so Mr. Silal Pagzola had withdrawn himself,
Yes, my lord.
and then now you're the
Your
new
first
counsel.
appearance, yes, my lord.
Okay. Heard Ms. Lalopari.
Yes, my lord.
Learned counsel for the appellant, who submits that. What's your submission?
If the matter can be taken up on 22nd of July as a fixed item.
Who prayed that the matter may be adjourned and be listed on
22nd July.
22nd, 2025.
22nd July, my lord.
Okay, 22nd, 7.
Yes, my lord.
2025. Full stop. Then who is the counsel for the respondent?
I'm appearing on behalf of respondent number 1. Respondent number 2 is not represented today.
Have you the thing
Yes,
informed
yes, I inform, Mr. Yes, my lord.
the learned counsel for the submits that she has also informed the counsels for the respondents. Full stop. Ms. Caroline Gaylor Longpui, Learned Counsel for the State Government Advocate for.
No, my
these-
lord,
In your private capacity?
yes, my lord,
Okay.
as respondent number one.
Mrs. Gaylor appears on behalf of respondent number
Respondent number 1.
1 and has raised no objection. In view of the above, as prayed for, list of so-and-so.
Obliged.
Item 6.
Yes, donation application.
Yes, Lordship, this IA is filed by Mrs. Vanit Siami.
Where is she?
She's having a hearing matter in division bench. So she prayed that if the matter can be listed after a week.
Also, this is a simple matter. There is a delay of 353 days. Then I have filed my objection way back on May, Your Lordship. So this may be taken up Monday or Tuesday next week if Ms. Vanishim is not available.
Next week she'll be available.
Yes, well, I will inform her.
Okay. Mention is made on behalf of Ms. Vani Siami, learned government advocate, for adjournment of the matter, which is not objected by Mr. Johnny L. Totham, learned counsel for the respondents. In view of the above, as prayed for, list on,
Tuesday.
date.
Tuesday.
Okay, what's Tuesday's date? We have quite a number of cases on Tuesday, but it's okay. List on 24th, is it?
24, Lordship, yes.
Yes.
Obliged.
Item 7.
Lordship, in compliance of this Honorable Court Order 22/5/2025, I have taken steps upon the respondents number 1 to 3. But Lordship,
Not
this is
returned
not
yet?
returned, not returned, Lordship.
Can
may
wait for some time?
Yes,
Or
Lordship.
what? Huh?
We
can
may wait for some time, Lordship.
Okay, Mr. Johnny L. Totham, learned counsel for the applicant slash appellant is present. It is seen that AD card from the respondents, number 1 to 3.
1, 2, 3.
1 to 3 is not returned till date. We may await for return of AD card list after 2 weeks.
2 weeks, Lordship. Yes.
Part 2, item number 5.
Your Lordship, if I may just go and fetch my senior, he's in the other court.
Who is the senior?
Victor Erarte.
My lord, I have been informed that he can proceed his submission and he can come because he's the petitioner, we are respondent.
Yes, we can hear.
No, may I please, Your Lordship. My Lord, the main issue in connection with this writ petition pertains to challenging the selection and appointment for the promotion of health workers to the post of health supervisor, my Lord. And my Lord, here initially for promotion of these health workers to the post of health supervisor, my Lord. As per the notification made by the concerned authority, the criteria given by the concerned authority is that the health workers who are working under the Health and Family Welfare Department having not less than 5 years regular service in the grade are entitled to appear in the limited departmental exam. This is a promotion to be conducted, to be done by conducting limited departmental exam. And here, prior to issuance of the notification for conducting LDE, my lord, here approval was made by the concerned state authority, my lord. And my lord, here
So take me to take me to the documents to substantiate your submission.
My lord, yes.
What,
If I may bring your lordship to the request petition, page 20, my lord.
Page 20.
20.
So here's the approval
This
for
is
filling up of
this
post.
is the approval for
yes,
filling up
yes.
of post for health supervisor. And my lord, here, as per the approval, the health supervisor male and health supervisor female is the name of the post, my lord, at the time of approval. And the number of posts for male is 33, and for health supervisor female is 43. And the mode of recruitment is, my lord, here, promotion in respect of the health supervisor male is 11 numbers for male, and by way of limited departmental exam, 22 numbers of post, my lord. And for health supervisor, by way
Both
of
health supervisors, one is male, one is female.
one is male and another is female. And by way of LDE, male will be having the vacancy of 22 posts.
22.
And for female, they will have 25, my lord.
Okay, before we proceed further, okay. Now, I think a similar, something like this was disposed of in the DB before the.
Exactly, my lord, yes.
And it was disposed mostly on the grounds that the state government is taking steps to amend their recruitment rules concerning male and female. Was that done?
That was done, my lord. And that was done. And in the light of the order passed by the Honorable Court, they are directed to maintain a common seniority without classification of male and female.
Okay, anyways. So
But
continue.
during this relevant period, my lord, the approval was made by classifying the post. This is the period of 2021, my lord. The order, the approval, as per the approval letter, it was made on 5th November 2021. And my lord, after this, the notification, which is at page 22 of the petition. This is the notification for filling up of 22 vacant posts of health supervisor male and 25 vacant posts of health supervisor female at level 6 in the pay matrix under Health and Family Welfare Department. It is conducted by the Mizoram Subordinate Services Selection Board. And here, as I had already mentioned, my lord, the health worker under Health and Family Welfare Department having not less than 5 years regular service in the grade may submit their willingness using the common application form, so and so. So here, this is the notification, and the incumbents who are completing the criteria of 5 years regular service had submitted their application. And after this, the date for examination was fixed. Until fixing of the dates, there was no objection and complaint or challenge of the notification as such, my lord.
Okay, date for examination is 26 May. Yes, 26 May. Isn't it?
The date for examination is at, the notification is at page 23, my lord.
So it's on 26 May.
Yes,
Where's the
yes,
date?
that notification letter is 26 May 2022.
Yes.
Fixing the date of examination on 28/6 and 29/6.
Okay, yes.
And my lord,
So, they sat for the exam?
yes, the exam was conducted and it attained finality, my lord. The exam was
So the
conducted,
result was.
the result was pronounced,
Yes.
and the notification was made by the MSSB, which is at page 24,
On 4th June.
on
results pronounced.
14 June 2023.
Yes.
Filling the 47 vacant post, wherein the
Okay.
number of candidates are 115 in total. And my lord, here,
So the petitioners are, who are the petitioners in this list?
the petitioners in this case are not selected, my lord.
Oh, you're not selected in this, so
Yes.
you're not here.
We are
Okay.
not here.
Okay. So are you challenging this? No.
We are challenging this. We are challenging
Oh.
this. We are challenging this notification along with the appointment and promotion order, my lord,
Okay.
which is at page 30. Page 28.
Okay, now you are
These two orders
challenging
we are
this.
challenging, my lord.
Okay, challenging this, okay,
Yes,
this
my
order.
lord.
Ah.
Here, my lord, the main point is that
This and
As
the
per-
appointment orders. Where's the appointment order?
appointment order is at page 28, my lord. 11 July 2023.
Okay. Okay.
Here, my lord, as per the approval of vacancy by the concerned authority, and as per the notification made by the concerned MSSB, the vacancy is made like 22 posts for male and 25 for female. But as per the selection and result, extra 8 posts are given to the female, my lord. Meaning that 33
Page
female.
24, page 24 is a selection, is it? So
Yes, my
in
lord.
page 24, how many females?
33 female.
Okay.
The vacancy allotted for them as per
Page
the
24, 33 females.
33 female. And
Okay.
40
Females, while the
40
vacancy is only 25.
25, my lord. Extra 8 posts.
So you are some of the men who want to be appointed, is
My
it?
lord, my lord.
Okay. Ah.
Only female.
Only that point, is it?
That is the main issue, my lord.
Ah.
Only
okay.
14 male candidates are selected out of this 22 post already allocated
So how many
for the male.
petitioners are there? 14 of you or how many?
Petitioners, petitioners are 9, my lord. 9 numbers of male
So
petitioners.
eight posts.
8.
You're saying that they're exceeding by 8 posts.
Yes, my lord.
So 8 posts. So there should be eight petitioners. Among
Yes.
the petitioners also there's some this thing or what?
Exactly, my lord.
Because if there are only 8 posts,
Yes.
which as per your this thing, which they've exceeded, 8 females have exceeded, and now there are 9 petitioners.
That in that
How will you
regard, my
settle
lord.
that between her?
My lord, in that regard, only the petitioner number 2 to petitioner number 9 are entitled out, meaning that when we obtain
Okay,
the
seven persons are fighting for 8 posts.
eight persons, my lord.
7 to 9, 7. No, 2 to, you said 2 to 9.
2 to 9, yes, 2 to 9 only.
2 to 9 will
Because
go
when
to
we
who?
inquired the
2, 3, 4,
results,
5, 6, 7,
which
8,
is
9. 8, 2 to 9.
which is obtained from the MSSB, my lord.
Hmm.
If the extra 8 posts are to be given to male candidates,
Then
they
petitioners
are
2
in
to
the
9 are
they are in
entitled.
the merit list, my lord.
Okay,
Yes, 2 to
fine.
9.
In the
2 to
merit
9.
list. Huh?
Yes.
Okay. Yes.
Except one, my lord. And here, in the course of issuing the selection result, the selection of the candidates, my lord, here the MSSB, there is no requisition from the concerned department in the event of any order from the Honorable Court to maintain commensurity between male and female, my lord. There was no such direction from the concerned department or the concerned authority to follow the order of the Honorable Court, my lord. So simply, the result
Okay.
was,
What is the order of the court? When was that disposed of, the court's order?
the
Date
court,
of, have you, that has not been attached in your writ petition, okay?
that is
So
attached, my lord.
basically, it's for
That is
the
attached.
petition, where is it?
At page 30,
Oh, yes,
32.
at page 32.
32. It was disposed of on 9/6/2023.
Okay. But I thought some matter had come up before the DB also concerning this
Yes, that is
male,
correct.
female.
That,
don't recall
that
it.
DB, before that DB writ appeal was preferred, but the
Appeal against
DB
this
up-
judgment, isn't it?
Exactly, ma'am.
And then?
The DB upheld the order of the single judge, ma'am.
Okay, so the single judge is very important. So what does it say, single judge?
The single judge said that the if I may read from page 36.
The rules
madam.
do not make any classification. Yes, so you're going to read
yeah.
from page?
Page 37,
Yes.
second paragraph. Thus, on perusal of the Mizoram Health and Family Welfare Department Group C Post Recruitment Rules 2011, as well as Mizoram Health and Family Welfare Department Group B Post Recruitment Rules 2011, it appears that both the rules does not make any classification of health workers into male and female health workers. If the recruitment rules referred to herein above does not make any classification of health workers into male and female health workers, there cannot be separate seniority list of male and female health workers on the basis of post creation by the government. The post creation of health worker by the government is also required to be done in accordance with the recruitment rules noted above. In view of the above, this court is of the considered opinion that there cannot be separate seniority list of male and female health workers on the basis of post creation by the government in the absence of any classification of health workers into male and female health workers in the recruitment rules. Accordingly,
So the recruitment rules was challenged here, is it?
yes, by filing this writ petition,
The recruitment rules was
the
challenged.
recruitment rules,
Now, wait, yes. So in page
that
20, let's come
actually-
back to page 20, the notification, page 20. No rules were, this is for
there was
simply
no mention
filling up
about,
the post,
there was no
nothing.
mention about
No.
rules, my lord. Yes.
But you will fill up this post under which rule? What, this, so it will still be the
That was also
recruitment rule?
silent, my lord, yes.
But it'll still be the recruitment rules, isn't it?
There has to be, yes.
Anyways, then in this appointment, let's see the appointment.
Appointment is at page 28. The retyped copy is at page 30.
But all this will be based on some rule.
Yes, exactly, my lord. But those rules are silent. Not
The
mentioned.
approval of the, for filling up the post of so and so. That means there's a vacancy. They have to be based on some rule, 20, page 20. Anyways, So you're saying that, so what's wrong? There's a judgment here saying there's no female, male. Then what is your point?
My lord, my point is that initially the approval was made by the concerned authority, and the concerned government authority had
So
to make
this
the
was not
approval.
challenged. You're
That
saying
this was not challenged
challenged.
and had attained finality already. Till notification and advertisement was issued, there was no challenge at all. And after conducting the LDE also, the candidates appeared, examination was conducted, and in the meantime, as the order was passed by the High Court in a separate writ petition, saying that common seniority is to be maintained. Only
Okay, after the judgment was passed, what, selection list was out, is it?
yes, that result is pending during issuance of
Okay,
the
it was kept pending.
Malo.
Then after the judgment, the office order dated 11 July, selection list
Selection result was
result
issued,
was
yes.
issued
Malo,
only
yes.
after. Okay.
Yes, but in order to issue that office order selecting the candidates, my lord, there was no requisition, there was no official letters or correspondence available in the record or in any application submitted before the court to show that there was no requisition from the concerned authority of the state government by selecting the candidates in the light of the order passed by the Honorable High Court in respect of that common seniority. All those documents were not available, my lord. Simply the candidates were selected on merit based.
Okay, so no reference was made to the judgment, you're saying that?
My lord, yes, there was no reference at all. So simply all those extra 8 seats meant for male candidates was given to the female candidates.
Okay.
My lord, then after this, presently the promotees, 47 numbers of promotees had already joined their post, my lord. Now us as health supervisor. So, my lord, by filing this writ petition, my contention and my prayer is that
So all the promoted, the 8 numbers of females also, they have joined.
you have joined. You have joined
Okay.
already.
So what is the prayer portion?
My prayer portion is only if we can get these 8 extra posts for male. Because
But if
initially,
there are no posts, they have joined, so they have to be demoted and you have to be appointed
yes,
or
because
what?
that post is for, at the relevant period, that is for male post only. The vacancy
Okay.
is made unapproved by the concerned authority for male only, meaning that they cannot get the post.
Supervisor.
Yes,
Oh.
yes, my lord.
So now
That is the
you
thing.
are working as what?
We are working as health worker.
Health worker,
Health
and you want to
worker.
be promoted to health
Yes,
supervisor.
my lord, yes.
Now, if you say that you are the next persons, 8 persons, is there some merit list where your names are shown? To show that you are entitled?
My lord, yes, we have if in the regard, my
That is
lord,
not
here
there. How can you just claim that we are male, so we should be there?
that is available in the petition also, my lord, here.
Petition? Huh, where?
Uh,
Because 47 were taken. So page where? So you show me which page, you don't have to listen.
My lord,
That
here-
in the merit list, you are the next 8 persons, male, and therefore you are entitled to that. At least you have to establish, isn't it? Just simply being male and last, you should show how your right has been affected.
My lord, here, if this is available in the case record, my lord.
The case record
We had already submitted in the recast application, my lord.
in the
In the recast application,
recast application.
My lord.
Okay.
yeah, I can provide this copy also, my lord.
Wait, then it should be here. Let me see.
My lord. The recast application, the recast IA civil number 40/2020.
Recast, yes. Recast petition.
At page 20,
20,
21, my lord.
21.
This is the marks obtained by candidates in order of merit.
You filed on 12th November, is it?
Yes, my lord.
See, this is your recast, 12th November. Page
Page 22.
22. Page 22 is something else, it's notification. Please see, just showing if this is, wait, there are two recast petitions, just a second. Page 22. Recast petition, both of them are different. Sure. I don't find it here. This is a new paper you're showing me. It's not there in your recast. Or is it there and I missed it out?
My lord, this is the recast for the main writ petition, my lord.
Oh,
What I'm saying is the recast petition in respect of the IA.
oh, there's an IA. Show me the IA. It's here. Okay, so it's there. You're basically showing me. It's okay.
My lord.
So it's there and your marks are there. Okay. Then it should be okay if it's in the IA. I just wanted to know if it's there or not. Since it's there, it's okay. So that's how you're claiming that your rights have been there,
My lord.
because the next persons,
My lord, here the petitioners are at serial number 49,
uh,
50, 51,
in the
50.
IA, wait, let me see first.
my lord.
Where in the IA number what?
This IA is for,
Is there any other IA?
this IA is for implement of the petitioners number 229,
Page 20?
page 20, 21.
You see, because we have to be on the same page, and then if you establish that you have a right, you have been infringed, then we can proceed, isn't it?
My lord.
I don't find anything like that, what you have shown me. Is there any other IA? Then show me, give me all the IAs.
The IA is
Yes, no, they have not
40,
given me
my
one,
lord.
yes. They have given me one IA, but they have not given me all the IAs. They should be here then.
40,
Yes, it's here.
my lord.
So your serial number?
Serial number 49, page 22, my lord.
Yes.
49, 50, 51, 52, and 56, 57, 58, and 59, my lord. 49 to 52, and
But here, so what are you trying to point out?
what I'm trying to point out is that, my lord, if those 8 extra seats are
But
given
here,
to,
what it shows is consent not given to the board. Page 22. Or your marks.
that is only the marks only, my lord. The marks was not shown. This
Marks not shown.
Yes, in respect of those 49 to 52, consent was not given to the board and they are not issuing the marks only. But what we can see is this is in order of merit,
Okay.
my lord. In order of merit, the
So
serial
you're saying
number,
this is in order of merit?
In order of
marks,
merit.
But in some it's shown, marks are given in some paper one, so and so paper
Yes.
total.
only due to the reason that they are not, their consent was not obtained and they declined to record the mark, give the marks
Okay.
only. But that doesn't affect the merit
Okay,
list.
but you're saying that you are the next.
Yes, my
Okay.
lord. If those,
We'll accept that as a
my
as you
lord,
say.
my lord, if those 8 extra posts given to the female was to be given to male post, then this This,
The instant petitioners are the
yes,
next
yes,
amount.
yes. Petitioner
Okay,
number
fine.
2 to 9 are entitled to get the post, my lord. That is what I'm trying to
Hmm.
project, my lord.
Okay, so it's basically page 20 of your writ petition that you're basing your case on, is
My
it?
lord, my lord,
Page 20.
my lord.
The notice saying that vacant posts for so many. Yes,
Yes.
the respondents,
My lord, I have some
authorities? Yes.
authorities, my lord. If I, my first citation is, my lord, 2012, 11 SCC, page 656. In the case of Mahesh Chandra Verma and others versus State of Jharkhand and others,
Yes.
wherein
Para?
what I'd like to refer is at para 43. If I may read, my lord.
Yes.
Since, right from para 43, my lord. Since select list of 27 persons was duly identified as per the rules of 2001, after candidates from serial numbers 1 to 17 were appointed as regular additional district judges on 15/12/2001, the select list came to an end because, as per the affidavit filed on behalf of the High Court, though vacancies were not mentioned in advertisement, only 13 posts of additional district judges were available on the date of advertisement on 23/5/2001, and 17 posts of additional district judges were available on the date of recommendation, that is on 2010/2001. On the appointment of 17 regular additional district judges, the selection process for appointment of regular additional district judges came to an end. The unexhausted select list was wrongly used for appointment of 10 FTC judges, again out of the list of unsuccessful candidates. 15 persons were appointed as FTC judges. Their name were not there in the select list. The whole procedure was irregular. Reliance placed by the High Court on the impugned judgment of this court in Rakire versus High Court of Delhi and Surinder Singh versus State of Punjab is apt. It must be mentioned at the cost of repetition that on the 23/5/2001, when the advertisement was issued, the posts for FTCs were not sanctioned. Therefore, these posts were not even in contemplation. They cannot be termed as vacancies contemplated or anticipated by the High Court. Undoubtedly, the correspondence between the Law Ministry and the High Court indicates that the High Court was informed about the need for creation of FTCs and that fast-track court scheme may be brought into action in Jharkhand, but till the post for FTCs were sanctioned, there was no question of taking into account any anticipated vacancies. When the advertisement is for specific number of posts, the state cannot appoint more than the number of posts advertised. The select list gets exhausted when all the advertised posts gets filled. Up till this point, I'll read, my lord. This is the relevant point that I'd like to rely upon, my lord. When the advertisement is for specific number of posts, the state cannot appoint more than the number of posts advertised. And my lord, number 2 is 1996 4 SCC, page 319. Prem Singh and others versus Haryana State Electricity Board and others.
Yes.
My lord, here I will go to paragraph 25. If I may read, my lord. From the above discussion of the case law, it becomes clear that the selection process by way of requisition and advertisement can be started for clear vacancies and also for anticipated vacancies, but not for future vacancies. In the requisition and advertisement are for a certain number of posts. Only the state cannot make more appointments than the number of posts advertised, even though it might have prepared a select list of more candidates. The state can deviate from the advertisement and make appointments on posts falling vacant thereafter in exceptional circumstances only or in an emergent situation, and that too by taking a policy decision in that behalf. Even when filling up of more posts than advertised is challenged, the court may not, while exercising its extraordinary jurisdiction, invalidate the excess appointments and may mold the relief in such a manner as to strike a just balance between the interest of the state and the interest of persons seeking public employment. What relief should be granted in such cases would depend upon the facts and circumstances of the case. My lord, here I'll go to paragraph 26, my lord. In the present case, as against the 62 advertised posts, the board made appointments on 138 posts. The selection process was started for 62 clear vacancies, and at the time, anticipated vacancies were not taken into account. Therefore, strictly speaking, the board was not justified in making more than 62 appointments pursuant to the advertisement published on 2nd 11/1991 and the selection process which followed thereafter, but as the board could have taken into account not only the actual vacancies but also vacancies which likely to rise because retirement, etc. by the time the selection process was completed, it would not be just and equitable to invalidate all the appointments made on post in excess of 62. However, the appointments which were made against future vacancies, in this case on posts which were newly created, must be regarded as invalid. As stated earlier, after the selection process had started, 13 posts had become vacant because of retirement of 12 because of deaths. The vacancies which were likely to rise as a result of retirement would have been reasonably anticipated by the board. The board, through oversight, had not taken them into consideration while a requisition was made for filling up of 62 posts. Even with respect to the appointment made against vacancies which arose because of deaths, a lenient view can be taken, and on consideration of expediency and equity, they need not be caused. Therefore, in view of the special facts and circumstances of this case, we do not find it proper to invalidate the appointments made on those 25 additional posts. But the appointments made by the board on posts beyond 87 are held invalid. So here, my lord, what I'd like to rely in this decision is with regard to the decision that vacancies in filling up of the vacancies and deciding the matter, my lord, it's important to maintain the balance between the interest of the state and the interest of persons seeking public employment, depend upon the facts and circumstances of each case. By considering the expediency and equity.
So here, in this case, the points which were may be regarded as invalid.
This,
So here, the appointments made in excess was not invalidated, but they said that later the other post should be considered. Anyways, yes, next.
yes, my next citation is, my lord, 1994, SEC Supplementary Volume 3, page 308. State of Bihar and another versus Madan Mohan Singh.
Para?
Para 7, my lord.
Yes.
I'll read the only portion of the para, my lord, for the sake of brevity, my lord. And page 213, if your lordship may kindly see page 213, the bottom half, my lord. Bottom half of para 7, my lord. Right from as noted above.
Yes.
As noted above, the temporary vacancies arose subsequently, but even otherwise, in the view we are taking, namely that the particular advertisement and the consequent selection process were meant only to fill up 33 vacancies and not to fill up the other vacancies. The merit list prepared on the basis of the written test as well as the viva voce will hold good only for the purpose of filling up those 32 vacancies and no further, because the said process of selection for those 33 vacancies got exhausted and came to an end. If the same list has to be kept subsisting for the purpose of filling up other vacancies also, that would naturally amount to deprivation of rights of other candidates who would have become eligible subsequent to the said advertisement and selection process. Meaning that, my lord, here in my humble understanding, if there is an approval, a notification for filling up of a specific number of vacancies, it has to be filled up only for that number of vacancies and not beyond that, my lord. Here, in our case also, female are given 25 posts, but 33 are selected, giving extra seats, 8 extra posts to female candidates. And my next authority is, my lord, 2009, 1 SCC, page 386.
Para?
Para 44,
We
44.
have to see whether these, okay. Yes.
My lord,
Para
if I may
44.
read, para 44, my lord. It is a well-settled law that filling up of the vacancies over and above the number of vacancies advertised would be violative of Article 14 and 16 of the Constitution of India. Mere inclusion of the appellants in the select list of the direct appointees does not confer any right on them to be appointed against the vacancies reserved for promotees.
Okay.
This
We
is
have to
the
see whether
relevant
they'll be
portion.
applicable in your case.
My lord, my lord.
Considering the circumstances, yes.
And
Then the last.
the last one is this is 2005 4 SCC, page 148. State of J&K and others versus Sanjeev Kumar and others. This particular decision relied upon the decision made in Prem Singh that I had earlier relied upon.
Yes, yes.
Prem Singh and others versus
Para 7. huh?
My lord, yes, my lord,
yes.
my lord.
Okay.
This is the authority that I'd like to rely upon. And my lord, my prayer is, in the event of intervening in respect of the order issued for selecting the candidates and by appointing and promoting the candidates, my lord. Our prayer is that all those 8 extra seats which was illegally allotted to the female candidates is illegal, and it is liable to question set aside, liable to be questioned and set aside, as the 8 extra seats are to be given to the male candidates, my lord, as per the approval made by the concerned authority, and which was not objected and not challenged. And even after notification and issuance of advertisement, that was also challenged. And examination was conducted.
So when the matter was pending before the court regarding male and female post, this notification advertisement was never placed, was never challenged or what?
No, not challenged at all. Malu.
Okay, we'll have to see.
Malu. If it is required to rebut the submission, the argument, Malu, I may be given
Yes, yes.
time.
Therefore, respondent's number?
For respondent numbers 6 to 52, private respondents.
Okay, private
6 to 52.
respondent. Yes.
And besides the private respondents, the other respondents were state respondents and MPSC. And they have already filed a respective affidavit wherein they have supported the case of the private respondents. And my lord, before I address to the present writ petition, we have to look into the matter which was referred by my learned friend regarding the common seniority of male and female. That is, although I have stated everything in my affidavit, if I may take your lordship to a particular date, 12/11/2021, 12/11/2021. That is the date when WPC number 108 of 2021 was filed.
Okay, let's see.
The date is important, my lord.
Date, okay. It was filed, WPC, the one which he just referred to.
Yes, my lord. It was filed on 12/11/2021,
WPC
108 of 2021.
108 of 2021, yes.
And my lord, under the Health and Family Welfare Department, these health workers were governed by the recruitment rules of 2011. 2011. They are Group B. And the health supervisor post are also governed by the recruitment rules of 2011, Group C post. Both the health worker and health supervisors were governed by the recruitment rules of 2011, respectively, Group B and C. And these two rules are the recruitment rules which hold the fields, while the notification in question was advertised. Recruitment rules of 2011. And the recruitment rules of 2011,
Advertisement doesn't mention any rule. Anyways.
but at the time of advertising this post, this is the
they were
recruitment rules
under.
which hold the fields.
Yes, yes.
And if your lordship may kindly see, before that, my lord, this court in WPC 108 of 2021, while issuing notice of motion, had made an observation on 2/2/2022, which I have enclosed in my affidavit, saying that any promotion to the post of health supervisor or any further post shall be subject to the outcome of the said writ petition. Because the grievance of the petitioners in WPC 108 is
Okay,
that
wait, your counter affidavit is dated
17/1/2025. 17/1/2025.
You've mentioned that you have enclosed that.
Yes, my lord.
Okay, fine. Please continue.
I would like to refer the annexure in my affidavit, my lord. Affidavit dated 17/1/2025,
Affidavit in opposition.
filed by,
It is on 19/1/2024, is it?
17/1, 17/1, my lord.
2024, which year?
17/1/2025.
2025?
Yes, my lord. The earlier one which I filed is against the original writ petition, but thereafter, due to recast writ petition, I have filed this
Yes, okay.
affidavit afresh on 17/1/2025.
Page?
Page number 10, my lord. Annexure 1, page number 10. This is the recruitment rules of Group B. This is in respect of health supervisor. And if your lordship may kindly see the continue page number 12 of the same recruitment rules. Page number 12, we have the annexure of the recruitment rules and the name of post health supervisor, number of posts 171 or as may be sanctioned by the government from time to time. And on the following page, at page number 13, 1-3, my lord, at column 11. Have you got it, my lord? Column 11.
75%.
The
Yes.
method of recruitment can be by way of 75% by promotion and 25% by LDE. And under any circumstances, this either both the seniority promotion and LDE were termed as promotion. The method of recruitment promotion is different by seniority promotion or LDE. And upon bare perusal of these recruitment rules, my lord, there are no specification of posts for male and female. It simply refers to the entire sanctioned post to be filled up this person by way of LDE and this person by promotion. However, my lord, the state respondent had been maintaining separate seniority lists of male and female during the past several years, and being aggrieved, this WPC 108 of 2021 was filed, seeking praying inter alia for maintaining common seniority list to enable the employees therein to have common promotional avenue, either by way of promotion or LDE. So, my lord, after this writ petition was filed, the said writ petition was filed, this court on page number 16, my lord, in my same affidavit, page number 16, this is passed in WPC 108. On 2/2/2022, I will take the lordship to the relevant portion, page number 17. The last paragraph, page number 17. Any promotion made to the post of health supervisor and community health officer shall be subject to the outcome of the writ petition. And thereafter, my lord, the respondent authority, in the meantime, my lord, the respondent authority had issued the advertisement which was referred by my friend on 6/1/2022. 6/1/2022. The advertisement for the present post which the parties are holding. And being aggrieved, because we are aggrieved with this because they are
Male and female.
distributing the post to male and female, 25 to 22
6/1,
respectively.
Then what did you do
And we have
regarding
filed
that?
an IA in that
IA.
case, my lord. And which is, the order is in page number 18 of my affidavit, my lord.
Okay.
IA civil number 97 of 2022, which was disposed on 23/6, page number 20, my lord.
Yes.
It's a short order, if I may allow to read, my lord.
Yes, yes.
Heard Mr. So-and-so learned counsel for the applicants, writ petitioners, who submits that separate seniority lists of health workers, male and female, cannot be made in terms of Mizoram Health Group C Post Recruitment Rules 2011, herein after referred to as the rules of 2011 and its amendments. He submits that as per the rules of 2011, a common seniority list of health workers, male and female, will have to be made. However, despite the above facts, the state respondents have issued notification dated 26/5/2022 for filling up 22 male and 22 female vacant posts of health supervisor by holding a limited departmental examination on 28th and 29th June 2022 at Frank Bana College. He submits that the above attempt by the state respondents to fill up vacant posts of health supervisors should be stayed till the final disposal of the writ petition. Mr. So-and-so for the petition, appearing for the respondents, and Mr. So-and-so for the government. On considering the issue raised in the writ petition and in this
Before
application,
you continue, this is notification dated 26/05/2022.
this is in continuation of the first notification of 6/1.
Okay. After the first notification, a second notification was issued or what?
Yes, madam.
Okay.
Yes, madam.
Okay, for the date of examination.
That should be-
26/5/2022 is the date of examination.
Yes, my lord.
Okay. You're challenging,
madam.
okay, fine.
The bottom of the page, on considering the issue raised in the writ petition and in this application, this court finds that in the order dated 2/2/2022, issued in the main case, it has been observed that as follows: any promotion made to the post of health supervisor and CHO shall be subject to the outcome of the writ petition. In view of the above, while the selection process may continue in terms of the notification dated 26/5/2022, issued by the MSSB Mizoram, the final result of the said selection process should not be published without the approval of this court. I accordingly disposed of. And thereafter, my lord, as my learned friend had already addressed, in page number 22, my lord, the following page. This WPC number 108/2021 was disposed by the learned single judge on 9/6/2023.
So after that, the final result was published, is it?
Yes, my lord. And what I mean to refer here is that, my lord, there can be no separate seniority list, meaning thereby the next promotional post should also be in a consolidated manner, male and female in common. And this order was put to challenge before the learned division bench of this court, and Page number 29, my lord, annexure 5, page number 29. This is the writ appeal number 4 of 2023, which is filed against the said order. And page number 32, my lord, the relevant portion, this was, WA was dismissed on 19/7/2023, upholding the judgment of the Land Trial Court, amongst other, because even though one of the stand taken by the respondents during that period was that the recruitment rules was proposed to
In the
be
process,
amended.
Amended with male and
Yes,
female,
my lord.
but that never
But
happened.
that remains the same. That is the reason for dismissal of the writ petition, the writ appeal.
So the court was under the impression that male and female, this thing will also be included in the new amended
Recruitment rules.
recruitment rules, which never happened. Why
Which
didn't
never
it happen?
happened.
Because the baby comment was found to be more appropriate or what?
And so, my lord, in so far as this case is concerned, well, that writ petition is pending, and that recruitment was aware by the honorable court, and it was kept in abeyance, the result. And after disposal of the writ petition in favor of the writ petitioners, again, thereafter, this division bench order came. And now coming to the doctrine of merger, my lord, the interim order, whatever, is in respect of that 47 post, which held that this should not be done in this way. And coming to the present the final judgment, which attained finality and also confirmed by the division bench, the doctrine of merger applied in this case. And moreover, my lord, there is a recent judgment of the Honorable Supreme Court, which held that previously.
Let's read it.
Yes, my lord. It's reported in 2025, volume 2, SCC, page number 1. This is a landmark judgment, in fact. Previously, my lord, the general rules is that the rules of the games cannot be changed after the game is started. But the Honorable Supreme Court Constitutional Bench had recently held that if the rules permit so, it can be changed in the midway. Now, coming to the present case, this post distribution for male and
Rules are
female
not
was
there.
done initially 22 and 25. But that is against the rules. And in view of the recent order of this court, and as permitted by the relevant recruitment rules, that has been changed by making consolidated merit list.
So had the recruitment rules been amended?
No, my lord.
Had it been amended, I'm saying had it been amended, then maybe he would have had a case. But now it's not been amended till date. What happened? Because I think the impression that the court got was the recruitment rules were going to be amended, giving a separate quota to the females and separate quota to the males. But what happened? That was the stand of the government also at that stage.
The process of recruitment rules is very, very complicated, my lord. They have to consult each and every service association. But now, male
Maybe
are there,
therefore-
females are there.
Okay.
They have to be consensus.
Yes. Anyway, your judgment, para? You're referring to which
Yes, my
para?
lord. In this case, my lord, the Constitutional Bench of the Honorable Supreme Court had referred to various criteria of judgment regarding these issues. And in para 21, my lord, kindly see para 21. After referring to various judgments, they have made an analysis to adjudicate upon. Para 21.
Yes.
To effectively analyze and adjudicate upon the questions referred, we would divide our discussion into the following parts. 2.21.1. When the recruitment process commences and comes to an end. 2. Basis of the doctrine that rules of the game must not be changed during the course of the game or after the game is played. 3. Whether the decision in K. Manjusri Supra is at variance with earlier precedents on the judgment on the subject. 4. Whether the above doctrine applies with equal strictness qua method or procedure for selection as it does qua eligibility criteria. 5. whether procedure for selection stipulated by act or rules framed either under the proviso to Article 309 of the Constitution or statute could be given go by. 6. Whether appointment could be denied by change in the eligibility criteria after the game is played. So, my lord, after lengthy discussion of all these subject, my lord, the Honorable Supreme Court had came to a conclusion at para 65. Para 65.
Yes.
We therefore answer the reference in the following terms. Recruitment process commenced from the issuance of the advertisement calling for applications and ends with filling up of the vacancies. Now we are concerned with this 65.2. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement, which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness.
So, in your case,
It is
Article
according to
14
the
merit.
rules, and the requirement of Article 14 was met because all of them had appeared in the recruitment process without any prejudice.
and in the merit list, are they above the females that were selected?
No, my lord, no. my
Below.
lord. Below. They were below us. Number 3, my lord, if I may continue. The decision in K. Manjusri Supra lays down good law and is not in conflict with the decision in Subhash Chandra Mahawa. Subhash Chandra Mahawa Supra deals with the right to be appointed from the select list, whereas K. Manjusri Supra deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. Number 4, recruiting bodies subject to the extant rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adapted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Extant rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. However, where the rules are non-existent or silent, administrative instructions may fill in the gaps. Placement in the select list gives no indefeasible right to appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list. So, my lord, my case is clearly covered by this, and so far as the authorities referred by my learned friend, that in my humble understanding, that where the first one is pertaining to that posts cannot be filled up beyond the advertisement number of posts, and the rest are also not relevant, because even if subsequent vacancy cannot be taken into consideration as such, and filling up of posts beyond post advertisement is illegal.
And the rules, basically, it's
It is the rules. It is the rules to be considered, my lord.
Okay. Anything else?
So my humble prayers, before that, my lord, regarding the locus standi of the petitioners, initially this petition was filed only by the petitioner number 1. And he is not even the zone of consideration amongst the 8 top, amongst the male. So he has no locus standi. But subsequently, the remaining 2 to 9, they have filed an implement which was subsequently allowed. But although my learned friend had referred to some that he had referred to regarding the list of results.
The merit list.
But upon perusal of the writ petition itself alone, they have not made out a case of locus standi, my lord.
Okay.
So
Yes.
my humble submission is that the writ petition is devoid of merits and it may be dismissed.
A few additions here and there maybe, because I have the funerals to go to. Anyways.
Lordship, I have very limited submission because I adopted
Yes.
submission by my learned friend, counsels for the private respondent. So, my lord, like before I proceed, actually, the process was taken up by MSSB, we call it initially, and then that became defunct. And now, like a burden comes to MPSC, we step into the shoe of MPSC. Initially, we are not the party, so and we are newly implemented by your lordship
Okay.
as
Because
respondent.
initially you're not a party. Why
not-
were you not a party?
Because MSSB, all the process was done by MSSB, and all the
MSSB.
yes. Then that MSSB became defunct. It was no more existed. Then
Okay, okay.
then
later.
then we handed over all the things and we became a party.
Yes,
My
yes.
submission is on the base of record. That's I would like to say.
So,
My lord,
so you adopt these submissions made by
I
the
adopt, but
council?
I just want to clarify one thing
Uh-huh.
is that what I would like to say is that this petition was filed only after everything was settled by WPC 180. Because, my lord, MSSB, they had proceeded for this thing. They received approval on this one on 5th November 2021, as we used to do before. Because before, the practice is that they have heterogeneous group, female and male. Before that, though there was 2021
Okay, just give me
rules.
the full this thing for MSSB.
Yes, Mizoram subordinate staff selection.
Okay.
Mis-
Yes, yes.
Mizoram Subordinate Services Selection Board.
Services Selection Board.
Yes. So, my lord, I would like to appreciate the court by just noting some important dates. Some 5 important dates I would like to draw your kind attention. First, actually, we received on 5th November 2021, MSSB, they received the post vacancy. That should be done as per that female
2020?
2021, 2011.
2011.
My lord, that approval is November 5th, 2021. Then it should be filled as classification female and male as per that classification. And then we make advertisement. On that basis, we make advertisement on 6/1/2021.
Okay, you have that all in your counter, isn't it?
Yes, I have. And
Those dates,
yes, 6/1/2021. And again, that examination we are trying to conduct. That's why my learned friend exactly highlighted that they file IA. So it was going to be conducted at Champana College on 25/6/2022. Then that IA, what it was ordered is that let it go, all the proceeding, because that proceeding is pertaining to this selection process. So everything was finalized. Then that judgment was pronounced on 9/6/2023. We know the judgment. It should go ahead. There should not be classification between male and female. So then only after passing of this order, we came to know the order, MSSB. Then on 14/6, we announced result as per the order of the judgment. Though we had make advertisement for classifications of male and female,
So the judgment has
as per the
same
order, we
submission.
acted. Yes, that's exactly that. Then there is no illegality or any unlawful things we have done. So we just have done as per the judgment of the court. That judgment was preferred in DB, and that was also dismissed. That is what I would like to submit. That's it.
Yes, yes, Mrs. Mary. You're adopting the arguments or you're on this thing?
Your Lordship, I'll be adopting
Your
the
submissions?
arguments of my my learned friends on this side. And Your Lordship, the only ground that the state have in this case is that due to the
advertisement.
judgment in order, yes.
Isn't it the advertisement, so many so posts?
Yes.
That's his main point, yeah.
Yes. And then after that, the judgment and order have in the WBC 108 of 2021 have stated that there should be a consolidated common inter-se seniority list. So accordingly, the seniority list was finalized, and now the matter is settled. Even though the same issue was appealed before the appropriate forum, then it was dismissed at the motion stage. Now, I'll just take Your Lordship to one authority, which is GLT 2017 3 GLT 486. This is N. Asangba and others versus State of Nagaland. I will refer to para 9. May I read, Your Lordship?
Yes, please go ahead.
Admittedly, the orders promoting the petitioners was issued by the competent authority and they have been allowed to continue in their respective post for 2 years since then. Therefore, it would amount to travesty and absurdity in law to say now that the orders were issued without following the prescribed procedures and as such they have to be reverted to their post from where they were promoted. Moreover, to let the innocent petitioners suffer for no fault of theirs would be against equity and fair play. If government orders can be altered at any time on such grounds, it would lead to uncertainty and chaos in administration. Those who have been settled by an order issued by a competent authority should not be unsettled on whatever ground unless it is absolutely necessary in the interest of service and public interest. I'll just rely on this.
So you're saying that 8 female nurses, is it, female workers have
Yes.
already been promoted?
Promoted,
And the date
yes.
was when? How many years?
In Kuminzat, yeah.
When was it?
2023 July.
So 2 years. They have
Yes.
been holding the post for 2 years
So
now.
it's same.
okay,
The
right.
fact situation is same.
Yes. Anything else? Counsel for the petitioner. Anything else to submit, rebuttal?
My lord, here, what I'd like to rebut with regard to the submission of my learned friends, learned counsel for the respondents is that with regard to the approval of post, my lord, approval of post was made by the concerned authority, the policy makers of the government,
Okay.
and for only for the post of that male and female, clarifying the number of
And they
posts.
cannot back
That-
out
that-
now.
That,
I
that
think
was not
that's your
challenged
point.
at all, yes. And also, at the time of filing of the writ petition, my lord, that they are claiming for a common seniority only, not challenging the advertisement and identification, all those
Okay.
things.
This was not.
All this had attained finality till the
Yes.
contacting the examination.
I got your
And-
point.
My lord. So that is, meaning that that is not challenged at all by the respondents. So,
Yes, yes, I got
my-
your point.
my lord.
I'll pass you on. I have a funeral service to attend.
My lord, my lord, my lord.
Heard Mr. F. Lallian, learned counsel for the petitioner. Also heard Mr. Victor Ilratu, learned counsel for the private respondents, number 6 to 52, comma, Mr. J.C. Nisana, learned standing counsel for
53.
respondent number 53, and Mrs. Mary L. Kempe, learned government advocate for the state respondents,
1 to 4.
number 1 to 4. Hearing is concluded. Matter reserved for judgment. Yes.
Item number 12.
The parties were ready today, but we can
I
have
a-
we
this
can
thing,
we can we can have it
this
next
thing.
week.
If you want, we can continue. When I come back, we can continue at 2:30.
We can have it on
2:30
next week.
material.
In that case, we can have it next week.
Next week, 24th.
On the 24th.
Tuesday.
24th, we have fixed many cases.
Can we
From
have
the
it on Wednesday?
taken.
Wednesday, 25.
Is it possible on Wednesday?
Okay, so 25, we have make it 26th
Yes.
Yes.
on the 26th.
Yes.
Okay. Or if you want, we can have it at 2:30. I'll be back by 2:30.
We'll have it next.
26.
On the submissions made by the learned counsels for both the parties, list on 26,
June.
2025.
Right.